Our speaker this afternoon is Dianna M Rievaj. She is a barrister? Lawyer. And she is going to speak to us this afternoon on the importance of and the need for being legally apprised of your situation when dealing with construction. So, Dianna, thank you for coming.
Oh, breaking things already. All right, thank you guys for showing up. It's I was always saying to people, I know there's better things you could be doing besides sitting in a room with a lawyer, right? Thank you. I'm just going to move this a little bit so I can see my paperwork here. Yeah? There we go. I'm loud enough, I'm sure. So I'm a lawyer at Highlander Law Group. I actually own the firm. We're down the road there by Delish or by RBC, depending on your point of reference. Your microphone's running away again.
Nope. It's not my gear.
Just like this. Perfect. Okay. So my main area of law is litigation. So that's when things have gone badly. Something bad has happened on either your end or the contractor's end or whatever you're fighting with your neighbors about. And I got into doing these types of talks or workshops because years ago I ended up with a client who was a construction guy, and he had agreed to do. We can do this.
I'm just gonna stay up.
It's this guy. He was doing a renovation of a house in the south end, and they were basically taking off the roof, adding a floor, putting the roof back on. And he had a contract that he had done up and that he had obviously done himself on his computer at home. And as they went along, surprise, surprise, they found issues with the house, heritage house in the south end, imagine that. And so as they went along, he said, well, we could do this or we could do that. And the lady said, yeah, sure. And little by little, they added and changed. And of course, the thing ended up costing way more than they originally intended on because they discovered all these problems. So at the end of the day, when he's like, please pay me, the lady was like, I'm not paying you all that money. And he ended up having to sue her. And I ended up being the lawyer. And it cost him quite a bit of money because there were so many details involved and going back and trying to look at his records and whatnot. And by all accounts, he seemed to be a decent contractor, but his paperwork was terrible. And at the end of the day, partway through, like as we finished court, he ended up getting some of what he had asked for, but nowhere near what he really was entitled to. And the problem was he didn't have the paperwork to back it up. He didn't have a contract. And I felt really badly for this guy because he'd worked hard and he'd done a good job and he more or less got taken advantage of. And I thought, you know, if only I could get out there and educate contractors about the importance of getting stuff down in writing and really committing to what it is you're agreeing to do, you know, some of these people wouldn't get the short end of the stick. And so usually when I do this presentation, I'm talking to contractors, but it's the exact same information on the flip side to protect yourself. So I always start the talk off by saying a while ago, and this is true, a while ago someone told me there's nothing worse than being stuck in a room with a lawyer doing PowerPoint. So from that day on, even though I was very proud of my PowerPoint deck, I said no more PowerPoint, I'm just going to talk. So as we're going along here, I'm just going to share with you a bunch of examples and information and things that have come along my career to help you protect yourselves and to know what to do if a circumstance arises where you do end up in a conflict with a contractor. But you're free to ask questions. I'm obviously not going to give specific legal advice for specific circumstances, but if I'm explaining something and you have a question, you don't need to wait till the end because if you're anything like me, you won't remember the question 5 minutes later anyway. So my little chat here is designed with questions in mind, so feel free to jump in. So one of the main things that I want to impress upon you is that it's really, really important to have a contract in place. We're all so nicey nice in Nova Scotia that I joke all the time that our good old boy Nova Scotia handshake culture keeps me in a full-time job because people feel kind of uncomfortable, you know, asking somebody to, okay, let's put this in contract and make it official, right? But it's really important if you're hiring somebody to have the terms and conditions written down. And Fred had mentioned that one of the areas that the Seniors Association is exploring is the idea of casual work, like hiring somebody to come mow the lawn and whatnot. So, you know, you guys have all been around the block once or twice, so, you know, you don't need to have a 20-page contract to hire a guy to mow your lawn, but some of what I'm saying, you know, kind of file in the back of your head when you're making an agreement with somebody to do work and pay them, because you know, you are becoming, you know, the person that wants something specific done and they want to be paid. So, you know, it's really important to document what it is exactly and get everybody on the same page. I always say to people, there's no magic words in a contract. It's not like, you know, you go back a couple generations where a legal contract was, you couldn't even read it because it was heretofore and furthermore and onward to, and it's just, you can write it in plain old English. Doesn't have to be on fancy paperwork, doesn't have to be anything fancy. A good contract is a contract that outlines the expectations of both parties, and not only outlines what you expect if things go the way you want them to, but also outlines what is everybody's expectation if things go sideways, right? So if you're gonna hire somebody to do a job that you think is gonna take a month or two, and a week or two into it, you realize that you guys just do not get along, you're not seeing eye to eye, or buddy hasn't even shown up or whatever, there should be something in your contract outlining what happens if, what are we going to do here? So to take the lawn mowing example, you know, if you hire someone to come and they say, okay, I'll commit to come all summer long, I'll be there twice a week, but I need to buy a new lawnmower to do a good job, so can you give me a deposit up front for, you know, a quarter of the price? So you may think that's reasonable, and so you pay the fella, and then he never, you know, he shows up once, and then he shows up late the second time, and the third time he doesn't show up. You know, you want to be able to walk away from that obligation without him coming back to you and saying, well, look, I booked off the whole summer and I turned down all these other jobs to work for you, and now you owe me what you would have paid me all summer long. So you want to be clear about what the expectations are. The other thing that comes up all the time with contracts and contractors and these types of jobs is people will have a quote. I'll say, do you have a contract? And they say, oh yeah, I do, and they give me a quote. And then the quote will be to, I don't know, install a walkway down to the water for $2,000. Well, then it turned out when they went to do it, the land was more wet than they thought, so they needed more gravel, and then because they had to rent the excavator long, blah, 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 it ended up costing $3,000 instead of $2,000. And then the question becomes, well, was the quote intended to be a fixed price, or was that an estimate, right? So in theory, if somebody gives you a quote for a job, there's nothing wrong with using that as the contract. If you're signing off, both of you sign it and say, okay, I'm accepting your contract and we're moving forward with this. But you want to make sure that the quote has all of the details in it that a proper contract should. So in a proper contract, again, you want to outline the expectations, all the details for both the, you know, if things go well and if things don't. I recognize, again, especially speaking of the casual workers, again, you're not going to get into your, whatever, 20-page document and whatnot. So sometimes people come to me and say, well, I don't have any evidence of that. And I say, well, you do, because evidence can be your recollection, your oral evidence. You hypothetically, if you're in front of a judge, you could say, I met with him on this day, we talked about it, we walked around the yard, I showed him what I wanted done, and he told me $2,000. That is evidence. However, of course, Mr. Contractor is going to go up and say, no, that's not true at all. I went out that one day, we were there for 5 minutes, we only talked in broad terms, and I told her it could be anywhere from $2,000 to $10,000, right? And who's the judge supposed to believe? That's your classic he said, she said, right? So, you know, the best case scenario, and this is if you're going to take the roof off your house and put a floor on, you get the big, thick contract that outlines everything in detail. You have them sign it, they sign it, you have a witness involved, you know, you have this ironclad document that you can slap down in front of a judge and it's very clear. A lot of the time people don't do that, right? So then you move one step down where you have a contract and you both kind of sign off on it. maybe it's a contract that was emailed to you and you wrote back and said, okay, or maybe there's just an email exchange or a text exchange, right? So each one of these levels is still evidence, and it's just that from he said, she said versus the contract that you sat at a lawyer's office with, you know, if you ended up in a conflict situation, the further along the line with the more checks and balances there are, the better position you're going to be in. So again, depending on if you're hiring a guy to mow your lawn versus take the roof off your house, you know, put a little extra effort into it. And you would be shocked, I'm no longer shocked anymore, but you would be shocked how many people will embark upon a, you know, $250,000 project on texts. You know, like, oh yeah, I'll be there on Tuesday, okay, yeah, it should be about this much, labor materials, blah, 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 text. And it's obviously far from ideal if things go sideways. And the other thing too is, you know, back to the Nova Scotia culture and Nova Scotia handshake business, it's not to imply that, you know, any of these contractors out there are out to take you for a ride. Most people are hardworking and they're trying to do a good job, but there are lots of circumstances where things fall apart, sometimes through no fault of someone. You know, somebody comes in and they start working on your place and they got your bathroom, and then their wife gets in a car accident and they gotta go sit at the hospital, so they can't come do the job. Well, now what? Like, you paid the guy half of it, but only a quarter of it's done, and the materials are sitting there and you need to use your bathroom, what do you do, right? Or, you know, COVID is now my favorite example for everything, right? Like, lots of people had the best of intentions, and you know, you paid somebody whatever, and now they're out of business because they, you know, any number of crazy scenarios that came out of COVID, right? So you do want to protect yourself from these, you know, the one-offs that happen, and that they aren't one-offs, is the other thing, right? Like, I'm one lawyer in a tiny little law firm out here in the middle of nowhere, and it's my full-time job dealing with these sort of things. So, and I've been at this for, I forget now, 14 years or something like that. Like, this stuff happens a lot, so it's really worth your time to document what it is that you're doing, what the expectations are, and what will happen if things go badly. So, when I talk about a good contract, and one of the important things that needs to be in there is who the parties to the contract are. And that matters if you're dealing with a corporation. So if you're hiring a corporation versus an individual, it matters because if you have to end up making a claim against them, it's important to know, you know, what assets they may have. So if you're hiring them to say, I don't know, take down your barn and build a new barn, or add a new garage, or substantially renovate your kitchen. If you're dealing with a company that has no assets and has only been around for a year or two, and you need to sue them, you cannot go behind the corporation and sue the guy that has the nice house down on the Bedford waterfront, because you've only done a contract with the corporation. So it's important to be really clear about that, and that should be clear at the top of the contract, who the parties are. If you are doing a substantial job, it's worth doing a little bit of digging on the person you're doing business with. I had a lady call me last year, and she wanted me to help sue a contractor, and I was like, gosh, that name sounds familiar. So I did a little search, and I was like, oh yeah, I already sued this guy, and he's got 8 judgments lined up ahead of you, and we can go to court. He won't defend it, I guarantee it. We'll get a judgment, we'll record it against him, and you'll never see your money. The only person that will end up benefiting from this is me, because you're going to pay me, right? So some of these people that are like bad ones, you know, their track record is out there. They're pretty easy to find, right? So you do a little digging, you can do a Google search, you can, if you have a relationship with a lawyer, we can do a quick search at the Registry of Deeds to see if there's any judgments registered against them. You can go online to the court database and see if there's any lawsuits filed against them. So it is, again, if you're going to do something substantive, again, you don't need to do this against your guy that's mowing your grass, but if you're doing a big job, yep.
I'm just wondering, what difference does a contract make if there's a backup to the court system, or from what I hear, it's really hard to sue someone. It's really costly and you get nowhere.
So there's a lot of it depends on there. And I will, so my main rant here is about contracts, and the second piece of what I want to talk about is what your options are. So if we can hold that question, we'll get to it. And there is some truth to it, but it's not that you'll get nowhere. So the other thing that's really important, and some of this sounds so obvious, but I'm repeating it because, as I said, this comes up all the time, is you want to be clear what you're hiring the person to do. And this counts for lawn mowing. If you're just emailing or texting somebody, you do want to be clear. I want you to come twice a week, or if you're me, once a week. Or if it's somebody that's really particular, I want you there 3 times a week in July, and I want you to mow this area, whether you sketch it out for them or whatever. Maybe you have, I don't know, what are the lady slippers? Don't mow over there because I don't want you to mow down my lady slippers, or I want you to do this or that. Is it going to include whippersnipping? Like when you hire somebody to mow the lawn, does that include whippersnipping? Maybe you think for sure it does, and the guy with the lawnmower says, I don't do whippersnipping, I just sit on my ride-on, right? You want to be clear about who's bringing the lawnmower. Is this some kid showing up at my house expecting to use my lawnmower and I'm paying for the gas in it and the wear and tear on it? Or are they coming with their own equipment? You know, you want to be, some of these things seem so obvious, but this is where you get conflicts. Obviously, just one second, when I did a lease review for somebody that was opening a restaurant, and one of the renovations was that they wanted that the landlord was going to put a bathroom in, and that's what it said, landlord will add bathroom. And I was like, super, does it need to be wheelchair accessible? And they're like, well, yeah. And I was like, it doesn't say that in this contract. You guarantee the guy on the other side is not going to spend extra money to make your life easier. You know, does it need to be non-slip tile? Do you need a cabinet in there? Do you need 2 sinks or 1 sink? Do you need a soap dispenser? All these things that are really obvious, you have to list them out so that down the line, you know, if they, with this restaurant example, if they had said, yep, we'll put in a bathroom, and the landlord in his head thinking it's 10 grand because he's just going to put in standard everything, and they're thinking, well, no, it needs this, 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 and this. You know, it's really, really important to clarify these things. Question?
Which one about the texting? Does texting to stand up in court?
Yep, so like what I was saying there, you know, everything stands up in court. It's just a matter of how much weight a judge puts on it. So if you've got the he said, she said, the judge is like, I don't know who to believe, I wasn't there, and I don't know the 2 of you. I don't know if you lie all the time and you're as honest as whatever. And with texting, there's lots of room for confusion. But if you have it texted and it has everything listed out as clear as anything, and you can prove that the person received the text, then that's as good as anything else. Yep.
Diana, can you repeat the question at the mic?
Oh, sure. So she had asked, is texting, does that hold up as well as, you know, written contract? I mean, in today's day and age, you know, the court's moving ahead slowly and catching up to everything. But, you know, if it's something that's, you know, evidence that's in writing and you can prove that the person received it, that's as valid as anything else.
Another question.
Yep, sorry, go ahead.
If the contractor has a good reputation and is reliable, and he's not mentioning anything about a contract, is it advisable to have a lawyer with the contract that he's open to having a contract?
Yep.
Should there be a lawyer involved as well?
So the question is, if you're hiring a contractor and they have a good reputation, do you think it's necessary to go have a lawyer? So what I say to people is, if you're reading through the contract and it makes sense to you and you understand what all the language means and it appears to outline what what you're expecting, then you don't need to go to a lawyer. However, again, I'm just going to keep repeating the same example. You know, if you've got a lawnmower guy a couple weeks for the summer versus taking off, you know, adding a second bedroom or second bathroom to your house, and it's going to be $50,000, maybe it's worth a couple $100 to sit with somebody to make sure you've got yourself covered, right? So it's really a sliding scale of where your comfort level is. And, you know, if you've never had anybody into your house before and you want to make sure, then you certainly could, right? It's not going to cost, for something like that, my hourly rate is $275 an hour. Usually if somebody wants me to look at a contract, I say about 2 hours, because it gives me an hour to sit down and review it and look up anything I need to, and then an hour to sit and review with the client. And often it doesn't even take that long. So, you know, if you were hiring me, you'd be looking at whatever, $600-700. So if it's a $1,000 job, it's probably a waste of money to hire me. But if it's $50,000 job and it really matters to you, let's say you're putting in a dock or something where quality of materials and all that stuff really matters, you know, it might be worth it to you. So the other thing that causes a problem all the time is change orders. So let's say you're building this deck out here, and as you're going along, one of the parties to the wife will say, is flipping through the Home and Garden magazine, and she sees, oh look, I can get these plexiglass, instead of these posts, I don't want these posts, I want the nice plexiglass so I can see the beautiful ocean better. Can you do that? And the contractor says, oh yes, I can do that. And she says, great, go for it. And he says, all right, it's gonna cost a little more. And she goes, yeah, it's fine, right? So he goes and he puts in the much more expensive stuff. And then the bill comes in, he hands the bill to the husband, hypothetically. The husband turns around and he says, what is this? This is not what we agreed to. And the contractor says, oh yeah, I talked to the missus a couple weeks ago. She said she wanted this. Well, then what happens, right? She said she wanted it. They had a conversation. He's done the work. But nobody really agreed on the price. So did they agree? Did they not? So again, best case scenario is write it down. I joke with the contractors as they take the carpenter's pencil off your ear, get out the Tim Hortons wrapper that's in your truck. Write it down. Today I spoke with so-and-so, she said whatever, then you crumple it up, chuck it back in the truck that you never clean out, and then if you have trouble collecting, you can pull it out again, and there you have your evidence, right? So it's not perfect. Ideally, actually, you would take out your form from your contract that they would have and just fill out the change order, and you'd both initial it and away you'd go. And if you're the client, you make sure you find out what the price is before you agree to it, right? And the other thing that happens, unfortunately, all the time is contractors, this is what they do for a living, right? All day long they do plumbing, all day long they do electrical, so they know these things, right? But you don't, and that's obviously fine. So I always give the example of my poor mom who doesn't live anywhere near here, so she'll never know. I tell this story all the time. So years ago, my mom wanted a desk for a space in my parents' house, and so she wanted one built because she couldn't find the one she wanted. Fine, so she hires this guy, not quite a family friend, but a guy in the neighborhood that they knew he had a great reputation or whatever. He comes in, she sketches out what she wants, and he says, yep, I can build that, it'll cost this much, whatever it was. And she's like, oh, it's a little more than I wanted to pay, but it's gonna be beautiful, okay, I'll do it. So he goes away and he builds the desk and he brings it back and he puts it in the house and it's perfect. And then he gives her the invoice for twice what the quote was. And she's like, ugh, what, like what? What's going on here? And she's like, didn't you tell me it was gonna be, I don't know what the number was, $2,000 or whatever. And he says, well, yeah, but that was for materials. Obviously my labor was more than that. I can't tell you what the labor is before I build it. And my mom was like, oh yeah, right, of course. Sure, writes the check, pays the guy, and 15 years later the story survives, right? Because the contractor guy, this is what he does all day long. He does time and materials. He quotes his materials and however long it takes, he adds his time on. He probably didn't rip her off on how much time it was, but they never sat and had the conversation to say, oh, by the way, it's going to be hourly and my hourly rate is this and I estimate it's going to take another 10 hours, which is going to double the price, right? And my mom, being my mom, would just be too embarrassed to have like a debt outstanding and she doesn't like conflict. So she's paid the guy. But I'm here to tell you, lots of people don't pay the guy and they're mad about it and whatever else, and everybody's mad, right? So again, you want to get things in writing. And it's just, I understand that people don't love putting together a contract and whatever, but it's the effort to do it when everybody's on the same page up front is so much nicer than afterwards when the work's been done and it's super awkward for everybody, right? There's a question?
If you get a quote from the contractor with the way materials are right now, everything's up and down and all
Yep.
over the place, and so you get a quote, and then you go to the bank and you get the money that you need. Say a year later, you finally get your little house built.
Mm-hmm.
What if the prices of the materials have dropped drastically? Like now, it's COVID, the quotes are off the chart. So if do you trust the contractor to tell you that, oh, by the way, the cost of materials have gone down, so you just save $2,000, or vice versa?
So the answer to that, I think probably you guys heard it, but the question is, you know, what happens if the price of materials goes up or down between when you sign the contract, right? And the answer is, and this is a very live, ongoing thing right now, is it depends what your contract says, right? Because there's lots of people that early in 2020 hired Reivaj or whoever, I'm not picking on Reivaj, but whoever, home builder, to build a new house for $400,000. And then COVID happened and the price of lumber tripled and the price of, you know, everything went bananas. And it takes a year to build a house, and plus there were all the lockdowns and slowdowns. So, you know, a year and a half later, builders are like, okay, your house is ready, but instead of $400,000, it's $800,000. And homeowners are like, what? Right? And so there will be, I guarantee, a couple of cases work their way through the court to find out who's paying for what. Probably be more on shopping malls than houses, but they're going to have to interpret what was in the contract. Was it a fixed price contract, or was it based on the price of materials? So you can draft a contract however which way you want. If you want to do, it's called time and materials. So they, you know, they'll give you receipts for everything and say, you know, I ordered whatever 100 square feet of tile for your bathroom, and here's a receipt for it. And then usually they mark up the materials by whatever percentage, or they add a management fee on top of it, and then they charge hourly for their time. And a good invoice should say, Tuesday, May 5th, worked 4 hours on the grout. Tuesday, May 6th, worked 1 hour on the whatever, right? So you want to put it in your contract what the expectation is. Sometimes somebody will come in and say, yep, I will build that whole bathroom for $5,000. Boom. And that's what it says in the contract. And so if the cost of materials goes up, well, too bad for that guy. And if the cost of materials goes down, or he gets something at Bob's Bargain Basement, then good for him, right? And again, the idea is decide what's acceptable to you before you move forward. If you're happy to pay $5,000, pay your $5,000 and don't worry about the cost of materials. But if you want to get sort of your fair, what you believe is a fair deal, then put that in to say I'm doing time and materials and I expect receipts, right? So, and also if this is what the expectation is up front, and somebody doesn't want to sign the contract, the question is, well, why don't you want to sign the contract? You know, I say to my contractors, you know, it's not written in stone. We all know it's written in Microsoft Word. So you type it up and you email it to your client and say, okay, you know, it was lovely meeting you today. I'm really excited about your job. I'm attaching the contract here that I believe outlines what we've discussed. Please have a look at it. And if I've gotten anything wrong, or you want to add or change anything, let me know. We can work on this together until it reflects what we both want. Like, that's the goal here, right? So if, you know, if just because someone slides a contract across the table, like, you don't have to sign it. Like, they're editable in Microsoft Word, I promise you, right? The other thing that needs to be covered off of is payment. Don't be afraid to talk about money, because that's really all the contractor cares about. So the question is, are they going to get paid a portion up front, like a deposit to go buy the materials? Or are you only going to pay them in chunks partway through? If you're paying them in chunks partway through, is it every 4 weeks you're going to pay them, or is it only when they're 25% done the whole project? If it's when they're 25% done the project, is that based on their assessment of things or your assessment of things? You can see all the ways that these things can go sideways, right, if people aren't clear about this stuff. You also want to be clear if tax is included or not. If a person earns more than $35,000 in revenue a year, you're supposed to be charging tax. Lots of contractors, especially if you're doing somebody on a casual basis, just to build a back step or fix boards in your rotting deck, they're doing it on the side. They're not charging tax. They don't have to charge tax, right? Timing is really important to write down. So I just had a front and back step built on my house on the weekend. I hired the guy last March to do it. And it took that long for them to, you know, get around to wiggling it in, and then it was supposed to be, and then there's COVID, and then my family had COVID, and they couldn't come, and just ridiculous number of delays. And contractors are hard to nail down these days, especially for a little job like a front and back step, right? So if your expectation is that you need a wheelchair ramp built on front of your house because your husband's coming home from the hospital with a brand new wheelchair, put that in the contract. It needs to be done by that date or else, right? And that way everybody's on the same page. You don't want the guy to be like, oh, geez, lady, it's beginning of June. Did you really think I was going to get that done by July 1st? You crazy, right? That's their expectation. So everybody, you want to get your expectations. And if the guy says, I can't do it by July 1st, you can say, lovely, thank you for telling me, and go hire somebody else, right? The other thing that's super important is insurance. So you want to understand who has what insurance. So obviously you guys all should have homeowners insurance or renting insurance if you're renting. But if you're having somebody in that's running power tools and dismantling your house and doing the wiring and the plumbing and important things, and again, this is not so much grass cutting guy, you do want to make sure they have insurance, and that should be part of your contract. And if the expectation is that they're going to have insurance, there should be a line in the contract that says you will confirm that you have X number $1 million of liability insurance, and you'll provide a copy of that to me before you get started, right? Because you know, my husband always makes fun of me that I'm come up with these outrageous hypotheticals, but what he doesn't know is most of my hypotheticals aren't really that hypothetical. I exaggerate them, but you know, imagine a scenario where you hire somebody to come in and do the rewire, you know, your older house, and Buddy messes it up, unbeknownst to you, he goes away and your house burns down, right? And so you go to make a claim against your house insurance, and the house insurance company's like, well, hold on a minute, this fire started because of that electrical work. We're not paying, go get him. So you go to sue Bob's Electrical. Bob's Electrical doesn't have any insurance. Who's building your house for you, right? So it seems sometimes like, oh, I'm just hiring somebody for a $500 job, but you know, depending on the severity of what it is that you're doing, you know, again, sliding scale, apply your common sense and life experience here, but you know, it doesn't take much sometimes for things to go horribly awry, and then you end up with these horrible situations, right?
What about permits? Is that the owner's responsibility?
So that depends on what you put in the contract, right?
Pardon me?
It depends. So the question is, what about permits? Who's responsible? And the answer is, it depends on what you put in the contract. In general, if it's your house and you are doing work to your house, you are responsible to make sure you have the right permits. However, if you don't know anything about how to go about getting a permit to add a new deck onto your house, you can put it in the contract that it is the contractor's responsibility to do it. And in the event that they don't do it, or they do it wrong, or whatever, then you can go back at them. And I think I said this already, but I will say it again because, again, sad story where somebody didn't understand. If a contractor gives you a contract and you don't understand something in it, please don't assume it's standard. Like there's no it's standard. It's a legally binding term that you're agreeing to be bound to. One of my current joys, I say sarcastically, is all these people who have moved from away. They were so gung-ho to get here, and with the crazy housing market, they've bought houses sight unseen, no home inspection, no property condition disclosure statement. Then they move in, and then we had all the rain and wind and storm this winter, and their houses are leaking like crazy. I don't know why I got all the leaky houses. I probably did 8 files, maybe more, where people bought a house, and the house is leaking. And they're like, well, but they should have told me. And I'm like, well, you didn't ask. Actually, it's buyer beware, you're responsible. And so I spend a lot of time saying, like, you know, hashtag adulting. Like, you know, if you don't choose to protect yourself, nobody else really is going to be bothered to care, unless you have kids that are taking care of you. It's really important to understand what's in a legal contract that you're signing. Yep.
Situation, I like the situation where I have a fire, the insurance company agreed, you know, it fell under the insurance.
Yep.
They sort of went out and got quotes to return the house to its original condition. Their drawings and everything else, everything out. However, the insurance company says, this is the fixed price quote. If the company goes over, the contract is between you and the company, not, but the insurance company is paying the contractor all the time.
Right.
So I don't have a lot of legal. But they haven't gone over yet.
Yeah. So the comment or question there is, you know, if you have insurance companies involved, and the insurance company is shoving somebody down your throat and saying, you're getting this worker and we're paying them this amount of money.
No. We
Sorry.
assessed the bids together.
Yep.
They offered me the chance to have a local contractor because it was a very big job.
Oh, they're saying, here's how much we're willing to pay you, but if it's more than that, it's your problem.
Yes.
Yeah.
Well, the contractor bid, we selected the bid between us and
Right.
agreed, but it's fixed.
Yep. So what you want to do in that case is, again, this may start with contracts. It's so important. Everything comes back to the contract because it's the evidence of what the deal was between you, right? So if you're going to hire a contractor to do whatever at your house, even if the insurance company is paying, you still want to make sure that the contract with this contractor you're working with is clear that you're only paying $5,000 or whatever the number is, right? Picture the insurance company as your, like, if it was me, my mom and dad. Let's say I want to build a fancy deck on my house and my parents say, okay, well, it should cost you about $5,000. We'll give you $5,000 because you're wonderful. So we'll give you $5,000. And I go talk to the contractor and I say, hey, will you build my deck? And the guy says, okay, and then it's $7,000. Well, just because my bankroll is my parents and they're only giving me $5,000 doesn't limit what I have to pay the contractor, right?
It was a very specific item on
Yeah.
the contract with drawings.
Yep, so you want to make it clear in the contract when you hire the contractor, say, I want you to do all these specific things in the drawing, but I'm only paying you $5,000. Do you accept that or not? And a lot of contractors will say, yep, sure, no problem, because they're pretty confident they can do it for $5,000. And someone else might say, nope, not doing that, no way, no how, because I have no idea what I'm going to run into. I think it's probably only going to be $5,000, but if I start digging up your whatever and discover I have to fix this, that, or the other, I'm not limiting myself to $5,000. If you don't want to pay me for the work, it's cool, I'll go do work for somebody else.
So the insurance company is the person paying the contract, well, but I don't even see the bill.
Yep. But you want to make sure that you are not responsible for more than what the insurance company is paying. Like the insurance company
Well, as far as I know, I am.
are what?
Responsible.
So if the insurance
What's
if the
maybe
insurance
not
company
limit.
hires a contractor and you don't have anything to do with it, and the bill is more than whatever number they've come up with, they're responsible, not you. If they say they will give you, $5,000, or I'm making that number up, they'll give you money. Yeah, sure. But if you are hiring the contractor, you have the power to decide who you want to hire and what the terms of the contract are, not the insurance company. If the insurance company is hiring the contractor, then they are on the hook if the insurance company goes over, or the contractor goes over, because that's their problem. And I'm sure the insurance company would like to give you the impression that you should pay the extra. But again, like, you got to think about the contract, and one of the terms, legal terms, is called privity of contract. Who's bound by this contract? So if it's a contract between you and the contractor, it's just the two of you bound, and it's whatever terms you agree on. If it's between the insurance company and the contractor, it's just between them and whatever they've agreed upon. There's not a way for the insurance company to make it so that you're on the hook for some unknown amount of money that you don't even agree to in advance.
Could they put a lien on your house if the insurance company refuses to pay the extra, and could the contractor put a lien on your property?
Yep. So the question was, can they put a lien on if they're not getting paid? And the answer is yes. So the next piece of what I wanted to talk about is disputes. And what comes up all the time is people contact me and say, I hired so-and-so to put in a new bathroom and they did a horrible job, and so I only paid them this amount because I have to go hire another guy to take out what they did and fix it, and I'm out this much money, and now this guy's still threatening to sue me, right? He's gonna put a lien on my house, right? So first of all, liens are not magic. And they're frankly only effective in a few small situations. So under the Builders Lien Act here, you are allowed to, a contractor is allowed to put a lien on your house if they've done work on your property at your direction anytime within 60 days after the last day they've been on your job. So if you've been negotiating with them for a year, they can't lien your house. They got 60 days from the last day they did substantial work on your house, for one thing, okay? They need to, they can do it the documents themselves, but the way the land registration system is set up, 9 times out of 10, they're gonna go to a lawyer, so it's gonna cost them money to do it. It's a bare minimum $100 to register it, even if you manage to do it without a lawyer. And it just sits there and does nothing for up to 105 days after the last day they've been on the job. After 105 days, if they don't do what's called perfecting the lien, it expires, goes poof, does nothing. It sits there, but it has no force and effect. And in order to perfect the lien, what they have to do is start a lawsuit against you in Supreme Court, which costs a lot of money. To your point earlier, that's when you're getting into several years of whatever, right? So lots of builders will go out and file a builder's lien to be like, aha, I've liened your property. But if you're, Bob sitting in your house that you've been in for 40 years and it was a $10,000 job and you're not trying to sell your house the next week, the lien does nothing. It doesn't do anything at all, other than some people don't like the idea of it or they're embarrassed by it or whatever. But it literally does nothing. It's just a notice to anybody that wants to do business with that piece of property that there's a dispute about the property. So it's kind of like a red flag, buyer beware. There may be a claim that can attach to this property. So the time when a builder's lien works really well is if you're selling your property. So if someone's doing a bunch of renovations and they're trying to sell it, you can't sell a property with a lien on it because no one will buy it, right? So it'll hold up a sale. And the other time is if you're building and you need construction draws, because a bank will not advance money if there's outstanding builder's liens. So if you're bankrolling yourself or you're not expecting any more construction draws, and you're not trying to sell your house, the lien will just sit there and do nothing unless they perfect it, which most people don't, unless there's a huge amount of money at stake. Also, you have not been liened, or they haven't formally liened you anyway, until you get notice of it. So it's supposed to be by registered mail or personal service. So you can have somebody texting you like crazy saying, I'll lien your house. It's like you say, yeah, you go for it. Doesn't do anything, right? So the two ways that you can settle a dispute if you can't work it out yourselves is through small claims court or Supreme Court. In Nova Scotia, does anyone want to guess what the limit, most amount of money you can get in small claims court is?
5,000?
500, 5,000?
2,500.
The answer is $25,000.
Oh.
Most people think it's next to nothing, but it's $25,000 now, and it's $25,000 plus your court fees and disbursements. And if it's something that's been dragged on for a couple of years, you get prejudgment interest as well. So if you have a dispute with a contractor and he's got at the bottom of his thing 2% interest per month, which is valid, and it's taking you 2 years, you could have an extra huge chunk of change on top of the $25,000. A lot of times contractors will go the small claims court route even if they're owed more. Like my original guy from the beginning of the story, I think he was owed, I don't know, $45,000 or something. But we opted to go the small claims court route because he'd blow through $45,000 in legal fees trying to go Supreme, and it's a heck of a lot faster. So a small claims court, you can go online, download the form, fill out your name, fill out their name, fill out how much money you want or they want or whatever, and then there's a fill in the blank section where you describe what the problem is. You take it down to the court, they stamp it, they give you a hearing date, and you have to personally serve the other side. If you're using my law firm, we hire a process server so you don't have to do it yourself, but they just like on TV, you've been served. And then since COVID started, they start with what's called a pre-hearing conference. So you get on the phone with you and the other side and the judge, and they go through where the witness is going to be, what evidence is there going to be. I don't know, I assume they're still doing hearings by phone rather than in person. I think some of them are going ahead in person, but in general, they just want to outline what the evidence and whatnot is going to be, and then they set a hearing date. The hearing date will be like 2 or 3 months beyond that. You show up or do it on the phone. I call it mom and dad court, because basically you stand there and explain your side of the story, and they stand there and explain their side of the story. You can show your paperwork. If you have a witness, they can add in their opinion, and the judge, they're technically an adjudicator, they're not a sworn judge, they're a lawyer, but they make a decision. And to my observation, like mom and dad, nobody usually gets what they're looking for. So if you come in saying, I need $10,000, the judge is going to be like, well, yeah, but you didn't do this, and you didn't do that, and you should have done this, so we'll give you 8, and then he's getting a break on the 2, right? So it's much faster than Supreme Court. The rules of evidence are much more relaxed, and in theory, it's designed that you can go on your own. The filing fee, if you're asking for less than $5,000, is $100, and the filing fee, if you're asking for over $5,000, is in the neighborhood of $200. I realize you guys aren't sitting there thinking you're going to be suing people, and hopefully you aren't thinking someone's going to be suing you, but it does happen frequently that you hire a contractor, things go awry for whatever reason, you end up having to hire a second contractor, and it ends up costing you twice what it should have, because they have to not only do the work that may not be done yet, but they have to undo the first guy's work. So then you're out X number of dollars, and that's when you're suing the original contractor to say, well, if you had done your job, you would have gotten paid, but now I have to sue you because I got to pay the second guy. So that's how small claims court works. Yep.
I have a quick question. We used to have a business and we went to small claims court on a few occasions. And they found in our favor, but there was absolutely no way we had to collect the money. They
Right.
said, yes, you owe them the $20,000.
Yep.
But if they don't pay you, you have no recourse, except go to the other court and spend a lot more money.
So with small claims court and Supreme Court, you get the order that you get from the judge has the exact same force and value and weight as both courts. If you can't collect against somebody, it has to do with the debtor. So when I was giving the example of a contractor, that if you're doing business with a company and the company has no assets, or if you're doing business with the guy that I mentioned that I was asked to sue a second time, you know, if they have no assets and they have no income, you can't get blood from a stone, right? So your options are, so what you have to do is you take your order to down to the court, and they turn it into what's called an execution order. And then with that, you can go to the sheriff's office, and if you know where the person banks, the sheriffs will go to the bank and clear out their bank accounts, subject to a few restrictions. I think pensions are protected and things like that, but other than that, they take whatever's in that bank account. If you know where they work, they can garnish wages, again, down to a bare minimum for living. If it's a contractor and you know they're doing a job and getting paid from whichever other job, they can go to that job. I almost got to repossess a big excavator once. That was exciting. But you have to prove sufficiently to the sheriff's office that the person you're repoing it from actually owns it, so you need to provide serial numbers and whatnot that they can check. So if somebody owns valuable assets, you can give that information to the sheriffs and they will go repossess it, and then it just gets sold at auction. And the other thing that is very useful that happens is you register the judgment against their name at the Registry of Deeds. And it stays there, I think it stays valid for 5 years, and you have to renew it every 5 years, but it can go on pretty much forever. And then if that person owns a piece of property, that person has 1 year to pay you, or else you can sell their land under a piece of legislation called the Sale of Land Under Execution. And the idea is, look, if you own a piece of land that's worth something, and you owe this guy here $10,000, and you won't pay him, why should you get to own this valuable asset while Buddy's standing there with his hand out waiting for his money back? So we'll give you a year to sort yourself out, but after that, we're going to sell your asset on you, pay the guy back, and you can have what's left. So that's pretty valuable. The other thing is, technically, virtually every mortgage has a clause in it that says you're not allowed to have judgments against you. So if someone registers a judgment against you, we report you to the mortgage company. In theory, the mortgage can pull your mortgage right away. So, but that circles back to my very first point about know who you're going into business with, because you do want to know that if something goes wrong, like if you're doing a $50,000 job, or if they are going to do something that could potentially, I don't know, destabilize your house or something, you want to know what your options are. For Supreme Court, and this is to answer your question, this is when people talk about like you get nowhere, right? So you get a judgment against some contractor that's got 5 judgments against him already and has nothing. He has his old truck and his old tools, and he lives in a trailer with his mom. You're not going to get money from him, right?
Well, but it's really expensive to even go through that process, right?
Yeah, so for small claims court, as long as you can get your ducks in a row and explain yourself reasonably well, you don't need a lawyer. So let's say you're suing for $4,000. It's $100 to register or to file the thing at the court, filing fee. If you hire a process server, it's about $200, so it's $300. And then to do the piece, the execution piece, I don't think there's a filing fee for that at all.
I was thinking more of Supreme Court.
Yeah, so with Supreme Court, there's no limit. This is where the Irvings and Sobeys sue each other. And there are all sorts of, it's the opposite of small claims court. There's all sorts of procedure rules and timelines and forms and this, that, and the other thing. Most people are hiring a lawyer to deal with that, because if you miss a timeline or a deadline or you file something incorrectly, then too bad, so sad. And the court looks at that and says, well, you're here playing lawyer and you messed up, what are we supposed to do about it, right? Hashtag adulting, again. You can get in and out of court within a couple of months, depending on the circumstances, but in a lot of cases, it does take 2 years as an approximate timeline. With both sets of courts, you are allowed to keep negotiating with the other side right up until the judge walks away to make the decision. So a lot of times people will sue in Supreme Court, and that includes perfecting a builder's lien, with the expectation that they're not going all the way. They're just suing to scare the pants off you so that you'll start negotiating with them. Because the unfortunate reality is, anybody can sue anybody for anything at any time. I could sue you for sending the aliens to land in my backyard last night. I'm not going to win, but if I say the aliens caused damage to my house and you don't defend it, well, the court will look at that and say, okay, you didn't file a defense and you're putting forward evidence that's uncontradicted. I guess you get your order. And then I got an order against you for the damage the aliens did. So if somebody sues you, you have to defend it. And like I said, most of the time you're hiring a lawyer. And so you come to see me and I look at that and I say, God, this could cost you like $30,000, $50,000 more dollars. And Buddy just wants 40. So all of a sudden, when you weren't willing to negotiate with him, now all of a sudden paying the guy $25,000 to just be done with him seems more reasonable than, because I say that all the time to people, like, the only certainty when you go to court is that I'm going to get paid. Because I take my retainer up front, because I don't like to do debt collection against my own clients. And you don't know what side of the bed the judge woke up on, and everything is, there are rules, obviously, and they do their very best, but everything is very case-specific and fact-specific. And when you look at something and say, well, I clearly told him to do this, and the contractor saying, I clearly did it, somebody's perspective or somebody's interpretation is going to be wrong according to the judge, right? So you don't know in advance how things are going to go with the judge. So, there is, unfortunately, the cost of certainty is worth something. I have a gentleman right now that's way down Yarmouth Way, and he's got a piece of land with a right-of-way over another guy's land, and the guy sued him in Supreme Court over this right-of-way, saying that he didn't have a right-of-way and he needed to pay him all this money and whatever else. And I'm looking at it and I was like, you literally have a deeded right-of-way. It's a little bit convoluted, but you definitely have a deeded right-of-way. And we're at the position, and this guy is not terribly educated and wouldn't be able to present the case himself in court. And he's in the position that he's going to have to pay this is ridiculous, couple $1,000s to make these people go away, because if he goes to court on his own, he runs the risk of losing his right-of-way. And if he hires me, it's going to cost more than $2,000 before we get in the front door of the court. So he's going to pay $2,000 for a right-of-way that he already owns. So, which is a nice way to end my presentation, because it circles back to, if you have a good contract up front and make things as clear as possible and everybody gets on the same page before you start the project, there's a much higher, nobody ever comes to me with a really nice contract and says, here's the beautiful contract that we had the lawyers draw up and we both signed it and it has all our change orders in here and now we're disputing things. Never happens. I shouldn't say that. The COVID price increase probably is going to apply to some of those situations where they're saying, well, the prices went up so much, we're doubling our prices. So those are probably decent contracts, but 99% of the time it's, here are the texts and here's the quote that I thought was fixed fee and he says isn't, and all those situations. So that is the end of my things to share. Does anybody have any more questions? Yep.
I just wonder, you've touched on it, but I just wondered, in a case where you have a contract, but my brother was a contractor and he used to call it scope creep, that,
Yep.
Things
Yep.
got worse.
Yep.
That were unanticipated. Do you just put clauses in that say that you agree on as to how those will be dealt with if and when they are encountered?
Right.
In a good contract?
So the contract should say something to the effect of, like if I'm doing a retainer letter with people, I'll say, based on the information provided by you, I'm estimating it's going to take approximately X number of hours to complete this, right? And then down the line, if someone pops up and says, oh, by the way, I forgot to tell you this, or we discover that, then I can say, well, hold on a minute. that changes things a lot, right? And in that case, you know, if something happens or something unexpected comes up, you know, you do want to have a clause in there where you can say, okay, I'm out, right? You can say, you know, if the price goes above X, I have the option to terminate the contract, or if it's going to take longer than X number of weeks, I have the right to terminate the contract, or things like that. Because contractors will say it, and reasonably so, you know, if they take on a big dollar value project and it's going to block off 2 weeks of their time, especially in Nova Scotia where you only have 5 minutes of good weather, you know, they are within the rights. If you just breach the contract and say, I'm firing you, they can come back after you and say, you should have paid me this amount of money. I dedicated my time and gave away other work, right? Scope creep is actually is a little different than if something goes wrong. Scope creep is more like my panels on the deck, where they say, can you put the panels on? And oh, by the way, my neighbor has a nice, I don't know how to say the word, pergola, you know,
Pergola.
Whatever, pergola, yeah. Can you put one of those pergolas up? Yes. Oh, and can you make it pressure treated wood? Oh, and can you put one of those cement kitchen, like that's when you just add and add and add and add. And that's when you want to have the change order documenting who's agreeing to what and specifically what you're adding.
Okay, in my brother's case, scope creep was, he did renovating work.
Yep.
And, you know, high-end renovating work, and things they would uncover when they
Yep.
tore the house
Right.
apart that they didn't anticipate.
Right, and so he would say, okay, here's where we're at. There was one that I was involved in a long time ago where there was, again, another house in the south end, and there was something to do with the foundation. It was on
Exactly.
an old foundation, and the guy had quoted, and then when they took off this, that, and the other, they discovered that the foundation was a pile of rocks,
Right.
and they're like, okay, if you want us to go along, we now have to add building a whole new foundation to the price. Do you want to go ahead with that or not, right? And sometimes, and again, it's not necessarily people being nefarious, but sometimes the contractor's going to look at that and say, well, obviously you have to do it, because your house is going to fall down if you don't. And so they just go ahead and do it, and they add it to the price and say, oh, well, I had to do it, right? And it's like, well, no, you didn't. It was my house, and it's my money, and I never agreed to do it in the first place, right? So it doesn't matter what side of the table you're on. It's in everybody's best interest to be very clear up front what the expectation is, right? So, anybody else? Yes?
If you're dealing with a general contractor, is it a good idea to get the list of sub-trades?
Yep, so you can put that in the contract that you get notification in advance. I think most contractors probably won't go for that because they don't know, you know, 6 weeks from now they're gonna be able to hire Bob's Painting or Bill's Painting. They don't know who's gonna be available when the painting is. But you do wanna make it clear in the contract that if you're hiring the general contractor, that they are responsible for all of the things underneath. So if you're doing a substantial job and you're doing like bricklaying and I don't know what else, you want to have it in there to make sure that any contractors or subcontractors have the required licensing or permitting, or I don't even know what you want, certifications, and then you make it clear that it's on the general contractor to ensure that they do. So if they hire a brick worker guy and he doesn't do a good job, it's not on you, it's on the general contractor. So, okay, I know you guys have other things, and I believe you guys are going to learn a little bit about the program that the Senior Center is putting together. So, thank you for your attention.